talking about how to write an answer to a problem question. I'm going to be talking about it generally rather than specifically to a certain module like criminal or contract, but this can kind of apply to any problem question that you might get in law. And I'm going to be going through the structure that I think works best, as well as giving some tips on how to get as high a grade as you can. So to start with, it's really important to remember to treat the problem question as a problem question and not an essay. And what I mean by that, don't treat the problem question as an invitation to write an abstract essay about the legal issues involved in the problem. Problem questions are all about the practical element of law and how you would apply the law to a set of facts in practice. So the most common structure students use is called IRAC, or sometimes referred to as ILAC, and essentially this stands for issue, rule, application and conclusion. Issue refers to the legal issues from the facts that need addressing. The rule is when you'd identify any law which might be relevant to the question in which you can apply to the set of facts. The application is the really important part. So this is when you're actually applying the law, and this is where the marks are, as this is kind of really the point of asking you to do a problem question. Conclusion is essentially just explaining to the marker what you think the outcome could be. It's okay if there's a bit of ambiguity around it, as long as you just state that, it's fine. And there's not always a correct answer, as long as you're backing up your outcome with case law and with statute and good reasoning, you should be able to get really good marks. So when you're starting with your problem question, it's really important to read and examine the facts given. The facts are really important because they will determine the relevance of any legal points that you might make. With the facts, it's important to accept everything written in the problem question is true, even though it might not make sense. It's important to just accept them as being true. Also, you should look out for any missing facts, any omissions. And you can bring these up when answering your problem question. So for example, you might say that more information would be required to make a decision on whether the contract is binding. And finally, not assume facts which haven't been given. And don't think about what the position would have been if the facts were different, unless you're asked to specifically by the question. Because, it's not relevant and you'd just be wasting time by doing so and losing marks. So next, it's important to identify the relevant legal issues based on the facts. So this is where you'd look at the question and figure out what does the person want to know. So for example, they might want to know whether there is a binding contract and what the consequences are of this. Often there will be more than one issue, so it's important to consider the order in which you want to talk about the issues. And bear in mind that you want to present your answer in a logical and clear way. So for example, it's usual to find an offer first before seeking to identify whether there is an acceptance. So if there is more than one issue, or if you're advising more than one party, you have to deal with each one. You have to deal with each one separately. You could use headings if you're dealing with different parties, for example, or just use paragraphing. But either way, whichever way you choose to do it, you have to make sure that you're dealing with each one. When you do have more than one issue, it's really important to deal with one issue at a time and avoid jumping around between issues and discussions. So next you've got to discuss the law that's relevant to the fact. So you'd start by stating the relevant law, as this will make it clear that you've identified the correct law, and then you can cite supporting authorities. It's important to always give reason for your views and authority for legal principles and rules. If the legal position is unclear, then explain this uncertainty and give suggestions on how this may be resolved, including your own view on the most likely approach to be taken by a court. Now that you've identified the relevant law, you've got to apply the law to the facts and assess what is the most likely decision to be made on this issue. Again, as I said before, there's not always a right answer. In fact, examiners often use issues where there's a bit of uncertainty in applying the law. And in addition, there might be insufficient factual information to come to a firm conclusion. As I said before, applying the law is the most important part of the problem question, because everything else, the rules, you can look them up. The analysis is what really requires the actual thinking. So as a result, it's where most of the marks are. And because of this, it's really important to make sure that everything you're writing is relevant. Writing something irrelevant can not only detract from what you've said, but it also leaves you less time to say something that is relevant and that is important, which means that you might lose really good marks just by saying something that's not necessarily relevant. So I think it's really important to remember, if something doesn't advance your answer to the factual scenario, it's not worth putting it. So just keep it really focused on the facts of the case and applying the law to the facts of the case. So the conclusions and problem questions should be quite brief. They should essentially just be your position on the legal issues regarding the facts of the case. So whether you believe that, for example, there is a binding contract and what the consequences of this are for the person. You might find, as I said, that there are parts of the scenario that are a little ambiguous, or where there is a potential for different outcomes. This isn't a problem. It's fine to just indicate that you can't reach a final conclusion, but it's really important to explain why you can't reach this conclusion. However, if you can reach a conclusion, then I'd really recommend that you try to do so. So that was an explanation of IRAC, and now I'm just going to talk a bit about my kind of final tips on when writing your problem question. And the first one is creating the balance. So in terms of your application and treatment of different issues, I really recommend to avoid spending too much time discussing one issue that is fairly non-contentious, especially where this kind of takes away from the more important issues. I'd also say it's really important to avoid any vague and unsupported generalizations, and to make sure that kind of every sentence you're writing, there is a purpose to it and it's directly relevant to the question, just linking back to kind of keeping the focus on the question. Also, I'd say it's really important to avoid discussing at any length matters about which there's no dispute. So, for example, established and unquestioned principle of law. Again, it's just taking away time from the kind of more important issues that you could be talking about, which will actually bring you the marks. Having said that, you do have to fully explain the law, but it's unnecessary to say, for example, a House of Lords decision is of greater value than a Court of Appeals decision. Also, it's important to not just repeat the facts that are given to you in the question. There's no need to kind of rewrite the facts of the question in the answer unless you're making use of them to expressly identify the basis for your identification of this legal issue. So, in other words, they can be usefully incorporated as part of your discussion of the legal issues as an application, but facts are not something that you have to keep on referencing if you don't have to. With regards to the facts of the cases that you're citing, there's often no need to go into detailed facts of the cases, but it's also not enough to just state the case and move on. I'd recommend just talking about the facts that are directly relevant to the question, or where there are significant similarities between the case in the problem question and the case that you're citing. Those are my tips on how to approach a problem question. I hope this was really helpful. I hope you enjoyed, and yeah, thank you for watching.